to make presentment damages you, right? So, and it also depends on who you're tendering the bill of exchange to. So it's things you can, I'm not going to teach the whole lecture right now, right? But you can look in Article 4 where they actually have a statute that directs them to make presentment because they have a duty for ordinary care. It's in Article 4, 4202, I believe. But if you're not tendering to an entity that's considered a collecting bank under Article 4, you'll just simply articulate your damage in your pleadings, because you have to sue is what I'm getting at, for a specific performance, and also the damage articulated by way of y'all didn't make presentment. So if I'm paying you in approved by contract method of payment, and you don't do what you're supposed to do with it, you cannot penalize me, right? You cannot take some type of punitive action on me and say, well, we're going to foreclose based on non-performance. No, I did perform. You didn't do what you were supposed to do. So then you have to get into the whole equitable court thing, and you have to specify why it can be equity, because you're not looking at a remedy in law and also the good stuff. Again, not going to teach the whole lecture that way. That's one way.
You can go that route, or you can also request the aspect of was it a requirement for y'all to record the deed? Is it a law recording the deed through putting it on the registry? I mean, and then are y'all even registered to do business in your state? And
those are standing is basically what we getting at. That's another thing I was going to say. Standing.
Also, if you do under the Security Exchange Commission, file a complaint with the Security Exchange Commission, and then also too, you wanna bring in the CFPB, because it's also a credit transaction. They mix the two, but you're not supposed to mix the two with the transaction. But really, with the deed is separate from the deed of trust. The deed of trust.
We really don't need to teach her a lecture at the moment. She just asked how you could do it. I really want her to just realize the different mechanisms, and then maybe if she has a question on an explanation on one specifically, then we can go down there. That's why I talk about keeping it efficient and effective.
Ether, so you've had success with foreclosures?
Yes, ma'am. One discharged by way of a bill of exchange, and then one discharged by way of them challenging proper standing on the grounds of they were not able to provide that they. I don't know whose mic that is. One on the grounds that they were not able to provide actual proof of consideration, and whatever they tried to use as in the discovery, say, hey, we provided this, it wasn't proof. So just proper use of the evidence code. So in those two regards, yes.
Okay, can I say mine? Can I say mine, please? Thank you. Okay, if y'all know Mary Maglaya, she did. I did her 42-4, but they had jammed her case up to the point where they can't. The federal judge did not remand it back because it was a disposed case with a lot of fraud in it. You can learn how to do a federal case if you go to my website. Don't go right now because I'm going to change the price. If anybody want to go over there, so you can learn how to remove a state case. It can be a day or two before they're coming to evict you out. And you can remove the case over to federal court. Yes, ma'am.
Yeah.
And stay the case. They cannot come and evict you. If anybody wants to learn how to do that process, you can DM. I don't like being DM. Go call my number on my DM. Yeah, because sometimes it be too many people, and you might get all the way down at the bottom. But anyhow. Case number for these mortgage cases. I don't give up people information, reason being because there's monetary amounts on those cases. And even though people got to remember something, this is their docket. They're not going to let people see that you beat them because it's embarrassing.
I just said that, sis. That's what I just said.
It definitely depends on what grounds you beat them on. So if it's something that's clear and easy as standing, it's like, yeah, you guys, we didn't have proper standing. That's light.
Right.
That's why I said, like, it wasn't even spooky when I did it. It was just like, hey, bro, y'all don't have standing in particular. Y'all don't.
Right.
Because you can't prove the elements of a breach of contract. So you didn't have standing.
Now, Mary, I did her first one. Once I put it together for you, you know how to do it for yourself. I got another guy that be on here. And he said he charged $5,000. I don't even charge that much to start it. But lawyers say they're going to do it for you. Don't do it. And if they do take your money, they want $10,000 to $20,000. One guy said he spent $40,000 and didn't get anything. So all I'm saying is If you learn how to do it, at least you'll know how to do it for yourself. It's better to learn how to do it before you get in a situation. That
Yeah,
way you
yeah.
are not like rushed or you're not uncomfortable. You'll know exactly what to do. And if you're just getting into foreclosure, the first 3 months, the best thing that you can do is a counterclaim. When they don't answer the counterclaim because of whatever fraud, then you can take it to federal court.
So
So,
I say it
Always do a
like this.
counterclaim with the credit too.
right,
What's up,
exactly.
sis?
Okay, you had said, the two different ways to do it and you said you got success with standing, going to court, and you got success
With
with the bill of
challenging your
exchange.
adversary standing. Yeah, the plaintiff, right? The bank, the financial institutions that was sued did not have proper standing. Yeah.
Okay, and then the bill of exchange. So the company, I have is Freedom Mortgage. So they ain't like a bank like Bank of America. So do they typically like take something like a bill of exchange?
Well, that's what I'm saying, right? It's not about what they take. I'll tell you, that bill of exchange was not processed. I'm not even almost at a parent cap, which it was not processed, but that was the damage. That's the point, that you didn't make presentment, but you were supposed to make presentment. You can't tell me. It's like this. If I'm your landlord and you owe me $1,500 for the rent and you give me a check, but I don't go cash it, and it's supposed to be for the month of February, that's like me in March billing you $3,000 because I didn't go cash the check from February's month of rent that you actually paid me for. But until I go and take it to my bank so that they can make electronic presentment to whoever your drawee on your check is, I don't get the liquid from it. But that ain't your fault. That's my fault. So that bill of exchange was not cash. They did not process that. So we were challenging them on some, you need to go and make specific performance. And they want a specific performance, say, yep, you do need to go ahead and make presentment on XYZ. But then here's the problem. They didn't have it anymore. That's what I'm saying. It's nothing spooky. It was literally a procedural defect. They did not have that draft anymore. So they could not follow the court order. They said, look, bro, fuck with us for the 10K. It wasn't me, it was my sister. But effectively they were saying, fuck with us for 10K, lawyer fees, legal fees, XYZ. And of course she raised a fit like, I ain't paying them nothing. I said, hold on. Do you want to come on down with 50 and lose? Or keep fighting this up and stretch it out? Or do you want to come on down with 10 and just let them fake take their W? You know, so like let them down easy type of deal. So she paid the lawyer fees and the legal fees, gave them whatever bread was specified in their settlement agreement, and moved on. So she didn't have to come on down with the rest of that 50 plus. But that being said, when you ask the question, do they accept a bill of exchange? They likely are not going to make presentment of anything they have to physically put in the mail, because standard, what they do is they have tech, the little Micker ink stuff, right? They got tech where they'll scan a draft and then it'll make electronic presentment and then it'll generate a payment order. They send that to whatever collecting bank is supposed to collect it, and then they'll cash that bread out. But that's electronic presentment. You're not doing anything to where you can make any electronic presentment with your bill of exchange. It doesn't have those security features. It doesn't have ABA requirement security features and functions and everything like that. So they would have to actually put yours in the mail, and they don't do that.
Well, I got another question
Because I
too.
had got a letter from them, and the reason why I'm asking specifically on the bill of exchange, because I had got the letter and it said you can either submit payment or tender. That's what it said. So my eyebrows raised. I'm like, hold on.
You know what tender means, right?
Yeah.
It means offer. So it's not necessarily saying like, hey, you can offer us a particular type of draft or no, but it does not mean that either, right? But they're saying you can give us an offer, give us a different offer, or submit the bread to us, like typically a payment plan or something like that, or reduce something, some type of proposal that allow us to keep the account open and do XYZ.
Okay.
Right. Yeah, can I jump in real quick? I'm raising my hand.
Yeah. Let me take this real quick. I'm gonna get right to you.
Okay.
One thing that we don't pay attention to with this bill of exchange is we have to look at the contract. So people were saying they perform in accordance with the contract. Typically they do not, because they have it explicitly stated in the contract that the borrower agrees to pay in check or money order. It says that specifically. And if you're going to use the Uniform Commercial Code, there's a particular definition for check and money order, meaning it has to be drawn on a U.S. bank. The Treasury is not a U.S. bank. So this bill of exchange and draft that I'm talking about did not draw on anything. The U.S. Treasury was not the drawee, because it would not satisfy the definition of money order or check. That's something that is frequently not talked about in the movement at all, and it needs to be talked about, because you're not actually abiding by the contract when you tender them a bill of exchange or a draft that doesn't meet the definition of check or money order. because it has to be drawn on a U.S. bank, and the U.S. Treasury is not defined as a U.S. bank by law.
So look at
So
what the note says, how you,
to if
how
you're going to
you,
use that angle, yes, to make because what's the point? The basis for a foreclosure or eviction is a breach of contract. The four essential elements to a breach of contract: one, there must be a valid, legally binding contract. Two, the plaintiff must have fulfilled their duties completely under the contract. Three, the defendant failed to fulfill their obligations under the contract. And four, because of their failure to fulfill their obligations, there was a damage to the plaintiff. Those are essential elements, right? So if you're going to be the plaintiff and you're going to say you fulfilled your duties and obligations under the contract completely, and one of them is to pay by check or money order, you can't say you performed by tendering a bill of exchange that does not satisfy the definition of a check or money order, which is what you signed and agreed to on a contract.
Hey, Javon, I just wanted to tell you, I just spoke to Yusuf. He's grabbing something to eat. He said he's going to jump back on.
For sure.
Okay.
So if
Well,
you want to holler at him, you can hang around, but he's an expert when it comes to the mortgages too.
I got my question is in regarding to expungements, and I had I got an old OP that's on there, and I was under impression, well, I was told that OPs are unable to be expunged. Is that true?
I'm gonna keep it 100% G with it. I ain't gonna never cap. I don't know what an OP is, fam.
It's a order of protection.
Oh,
Order of protection.
oh, gotcha.
It's been my experience, those cannot get expunged.
Or sealed.
It's sealed.
Yeah. Or can it be sealed? Because I was going to try to do it myself, but I had the paperwork and everything, but I want to. So it's just so happened that I jumped on this panel, and I'm trying to follow everybody that's legal minded in regards to understanding or overstanding.
Javon, I will tell you, because of the nature of an order of protection and the
It makes sense
liability
that it wouldn't be
and
expunged.
the liability that the state have, they're not. I've never seen one in my experience. They're not going to do that.
Yeah, I agree. Just
Yeah,
right
but-
when you said
yeah.
what it stood for, it makes sense. Principally, it makes sense why
Yes,
it wouldn't be something that you
exactly.
can expunge. Especially
Exactly.
if it's sealed. Like, it wouldn't make sense, really.
Yeah.
yeah,
Yeah.
Mr. Ether, I did just check my note. It does say cash check or money order.
And I know this, like, this the thing, experience. Because the two W's I got with foreclosure specifically, I'm not going to lie to you. I got 3 belts promptly applied when I was, we were attempting to help some people using Discovery. They tore them Discovery efforts the fuck up. Objection interrogatories 1 through fucking 16. Objection to request for production distance. I was young in the game. I thought I was groovy because I was, using Discovery and whatnot. Right? So what I found is also when people make the argument of, well, no, I did perform, which is sensible because 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 it's with the contract. The contract says this bill of exchange is not a check or a money order. And at first, I'll be honest, we were looking at this like what they're trying to say is not, because it's not an ABA. It doesn't have ABA routing numbers on it because it's not in the typical attestation or not attestation, sorry, typical or due form. Are they looking for something in particular? Because the definition of a check or money order is this, and it doesn't say you have to have a routing number on it. It doesn't say it's required for electronic presentment. Hell, there's a bunch of things in the UCC that mention that you're not required to electronically to make e-presentment. It's by any means, mail, oral, whatever. So we got to looking at it. Well, why wouldn't it meet the definition of a bill of exchange? And I sat there and looked and said, you know what? Let me just ask this. Is the U.S. Treasury considered a bank? Because we all know of the U.S. code, right, that mentions that it's a financial institution. So I'm like, well, let me see if it's a bank. It's not a bank. Not a bank at all. We even found a couple of cases where people apparently have already made this argument before. That was like the U.S. Treasury is not a bank for any intents and purposes. So if it's not a bank, it could never satisfy the definition of check or money order. And if it can't satisfy the definition of check or money order, that means we did not perform in accordance with the contract. So if you look at the definition of a bank in UCC 4, can't remember the definition sections, 10, 2, 3, or 4, one of them. It'll tell you loan and savings accounts, I think savings associations, any person engaged in the business of banking or a trust company. So like I said, I'm not going to treat the whole lecture with that, but a person engaged in a trust company don't have specific requirements as it relates to satisfying the definition of a bank. So you're able to leverage maybe some trust that you have, some type of association you have, some business persons, and keep a ledger. Have somebody hold some money, or have some organization or board of trustees hold some money for some particular reason. And then also have people make withdrawals from it because they can privately contract that way, thus satisfying the definition of a bank in banking activities. And then you make that entity or person the drawee, and it satisfies the definition of a check or a money order. 100% does. No, I ain't gonna never cap with you, never in life. But yeah, that's what it is. You could even give, let's say, a trust some money, and then have that trust issue you, let's say, a draft, because that's exactly how a money order works. And that you have some practice with that. You put that in one of the stipulations in their abilities or some of their duties or what commercial activities they facilitate. Something as simple as a 1-page document, and now they're engaged in the business of banking. You gave them some bread so that they can produce for you a particular type of draft, so that when you tender that to somebody and they make presentment back to that entity, they'll send the wire. But here's the thing. Are they going to make presentment? That's the key. Are they going to make presentment? And they typically don't. And then what we also found is they typically don't even have a damn draft no more.
Mm-hmm.
That's how we
So
got that.
ain't that's like even if they accept it or not, it's still discharged?
That is a misappropriation of what some people are saying. So if you on Cornell right now, you can even Google legal tender. If you Google legal tender, it's really interesting. But look at the bottom paragraph, and y'all can do it, right? Google legal tender, look at the bottom paragraph, and I think one of the last sentences in the bottom paragraph is it mentions each court in their own jurisdiction can decide what's effectively going to be used as acceptable legal tender. But it says essentially tendering, just simply tendering it, whether they 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 and accept it in this instance in order to pay off the debt. Although the original creditor who is owed money is not necessarily obligated to accept the tendered payment, the specific act of tendering the payment absolves the debt. That is in a particular instance, because what you should also do is when you read that, I don't know if you have Westlaw access, right? You got to have some tools which require some subscriptions. I don't know, maybe some people's ChatGPT can probably speak to it depending on how you've programmed it. But I wanted to see in which regard that will 100% stand. And what we found was it was a particular instance where you have a court order, like with a court. That's why it's specifying the top part says the government is going to define what legal tender is. The bottom part says it's for the courts to determine. So it's specific to court orders. So if there's a court order for somebody to pay some damage or something of the sort, and they tender it and offer it, it absolves them of their obligation. So in that regard specifically, it's not a coincidence that they separated into 2 different paragraphs speaking about how legal tender refers to all U.S. coins and currencies issued by the government. But then there's a separate paragraph that mentions, well, it's up to a court in this particular jurisdiction. It's because in those instances where there's a debt obligation by way of some court order, that's what it's referring to specifically. That in that regard is where if they don't accept it, you're discharged of your debt. You're still absolved of the debt. That's in court.
Okay, thank you so much.
Very welcome. Those are good questions though, for sure.
Welcome back, Yusuf.
Hey, what's happening?
What's going on, OG?
All right, so I'm back. She asked me to come back. What'd you ask me to come back for?
It was a gentleman on there that wanted to
Javon just dropped off. He wanted to
just drive too. I don't see him.
man, where did he go that quick?
I don't see him in a request either.
And Orlando also. He just dropped off.
Oh, here you go.
Wow.
I got him. Here you go.
Oh, okay. There you go, Javon.
Hey man, I was trying to catch you. I sat on here for about 2 hours, man, waiting. I was like, man, I'm a big fan, man. I follow you on YouTube, man. I've been following you for about a couple of years, and I didn't recognize the voice at first, right? Until I sat there and I thought about, I said, that voice sounds familiar. And I said, whoa, that's my man's, man. And, so I said, let me come on here, come time back in, and let me give him his flowers, you know what I'm saying? Let him know I do follow him, man. You know what I'm saying? I'm a big fan of yours, bro. And I don't follow nobody, really, like, in regards to giving them like flowers type of deal. You dig?
I appreciate it, bro.
Yeah, so when you jumped off, I jumped back in, was like, hold on, wait a minute, man. Y'all done ran the man off, man. So, but I just want to introduce myself, man. I'm Javon Master Barber, man. Check me out. Look up my page. You could run through it or whatever, man. Like I said, I'm a fan of yours, man.
I appreciate that.
Yeah, I sent you a follow request that way. You know what I'm saying? Because you got, like I was saying to the panel, you got a lot of 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 got a lot of
Referencing UCC 3-603B. Okay, and you have something called accord and satisfaction. And what he was saying, what he was saying about Tinder. Okay, you have to see. You're not supposed to go to court at period. Everything he's saying is contingent upon you going into a public court. You're not supposed to take private processes in a public court because it's going to get reinterpreted through statutes instead of contracts. The whole key to all of this stuff y'all been doing is to public and private does not mix. You got to keep private matters private and public matters public. I'll give you an example. Rupert Murdoch, he has an irrevocable trust for Fox, and it just got in the news because he tried to go in and change it because his son, who was the CEO of the corporation, was trying to flip Fox News from being a conservative news station to a moderate news station. And he wasn't having that shit. And he was trying to remove him from the trust, and he wasn't able to do it. But he took a private trust and put it into public. And everybody, including me, yours truly, was trying to pull up that case because that means you just took your private trust and put it into the public. We all get a chance to read that shit now. But they put a seal on it, and he had to settle out of court. When you do private ordering, you're supposed to be going into arbitration. Arbitration is the tool that you use, not the courts that you're going into. Those are administrative courts, and they are there strictly to enforce compliance to public policy. That is it. They don't acknowledge anything private. That's something else I had to come to terms with. As a private individual, you ain't supposed to be doing none of that stuff in a court. All the stuff y'all doing in a court. And you know what? Somebody gave me the rules when I first started. There is a public and a private, and they don't mix. There is no money. You have to stay in order at all costs and stay out of the courts. And I didn't understand that last part, stay out of the courts. But private matters don't belong in a public forum. Just it. That's just it. You know, when you really start studying this on a deep level, you'll see where you've been wrong and where you had a misunderstanding about things, how things actually supposed to work when you are conducting your affairs privately, how that works. Because the public, you don't have any power in the public.
So, Mr. Yusuf, so you on a mortgage, like with facing foreclosure and all that, is the arbitration clause for that?
There is. Okay, like what are you trying to do with a mortgage? Give me a scenario what you're talking about with a mortgage.
Like discharge the mortgage.
Okay, when you discharge a mortgage, usually it's going to go something like this. First of all, what type of instrument are you using to discharge the mortgage with? Is it a promissory note or a bill of exchange or a check or something like that? Obviously, most people try to use bills of exchange, which are three-party instruments, which means it has to draw from something, which means you need to have established some sort of secure party process. That's what that does. The secure party process is just setting up a framework for you to make claims and then have the government discharge it for you. That's what the process was intended for. A promissory note is a two-party instrument, and most people don't want to take them, especially if mortgage and you tendered. What I used to do was this. The first thing I would do is I contact the mortgage company and ask them for a 30-day payoff. A 30-day payoff. All right. The 30-day payoff is going to calculate all the principal and interest, because what you're attempting to do is do a set off, and you need the exact amount. And then I'm going to send that to the CFR with directions to take it to the bank, the Treasury Tax and Loan Department of the bank, to send a Fed wire to the Treasury Department. I'm also going to contact the Treasury Department and let them know what's going on as well. All right, now, after you've done all of that, okay, when you go into court, the first thing is going to be said, they're probably going to say your negotiable instrument is a worthless piece of paper or something like that. You always have to object to that. You know, you say, objection, Your Honor, that is not for the court to determine. That is for counsel to take that back to his client. They can return it to me with evidence of a defect from a qualified third party and allow me an opportunity to cure. Why am I telling you that? Because negotiable instruments have rules. You just don't throw shit out there. There's rules. You have to make presentment. And we used to do this. See, a lot of y'all are young, so you didn't grow up writing checks. When you wrote a check, if it was a bad check, they would return it to you and say, hey, there's insufficient funds. I need an alternative form of payment. So that's what you're looking for also. You're looking for, okay, you have to, that's when I'm saying you need a third party who can identify a defect in the instrument. That's asking, what are you saying? There's insufficient funds. Is there something wrong with the instrument? You have to identify that. You just can't say, I don't accept this. That's not sufficient. They'll get away with that in courts because people don't know how to object to it properly. There's rules to negotiable instruments. Like, for instance, they don't give you the instrument back because you don't have a claim on it. You're not a holder in due course. That's UCC 3-302. UCC 3-302 ties into UCC 3-305 and UCC 3-306. Tender is UCC 3-603B. That's what you were just talking about, like in it discharge up to the amount of the tender. What you're quoting is UCC 3-603B under enforcement clauses under the negotiable instruments. But the thing about it is at the end of the day, the public courts are there they're not judicial courts. They're courts, and then you have to do this in equity too. You can't do this in a statutory court. This is an equitable type of matter. It's an equitable remedy. It's not a statutory remedy that you're supposed to be using at all. And nothing is going to work for you in a statutory court, because statutes are there to enforce compliance. And anybody can chat GPT what I'm saying. It's there for compliance. They're not there to adjudicate matter. They're there for compliance. And that's what I mean by understanding the difference between public and private. But as far as a mortgage is concerned, you can attempt to set off a mortgage. You know, I used to do a lot of that, back in the day. And I had some success doing it, but you're going to have a lot of failures, and trying to learn how to do it. But the thing about it is when you tender a negotiable instrument, you are doing what is called engaging in performance, because that's what they're going to look for. When you go into the court, see, I got a lot of court experience going into the courts. When you go into the courts, what the court want to know, like if you're in a unlawful detainer or dispossessory action, you're not there on a title matter. So you're there because you're looked at as a tenant at sufferance. You're in a property that is not yours, and they want you gone. To bring title into it, you have to answer properly. And the proper answer is that there is no landlord-tenant relationship, that the court is going to give you a hearing. And that hearing, that is when you're going to bring all your evidence and try to get it pushed over like a superior court or something like that, because you got to bring title into it. And I'm going to say this to you too. I would never discharge a debt if I didn't have to on a foreclosure. I would do it when I'm current on my mortgage, and the administrative process is about 21 days, and then I'm filing a quiet title action afterwards. And I might try to seek a declaratory judgment first in an equity court first, and before I go into a quiet title action to get a ruling on my process to see if it was sufficient or not.
Well, could I ask this question, Yusuf?
Yeah, go ahead.
All right. So what I'm saying is they already take out an insurance policy against the actual mortgage. So by the 91st day, they're not taking a loss on any aspect of it.
Okay, that's
So
fine. Do you got any evidence to substantiate that you can bring into court that's verified?
what they took the policy against the
Yeah, you
the
got any
mortgage?
verified evidence to substantiate? I'll tell you where to find it. What you can do if you have let's say you have a mortgage through MERS. Pull out your mortgage paperwork. On the front of it is a MIN number. That stands for mortgage identification number.
Right.
You can take it over to MERS lookup, put in that number. Now, they used to give you the name of the trust that is being traded in, but now they want
They
you to
don't do that
contact
no
them.
more.
Yeah, they want you to contact them now
Right.
because people were finding the name of the trust. And then once you get the name of the trust, you can look up the trust on seccinfo.com,
Right.
and then you can pull the B424 prospectus. And then you can find that insurance information in there that you're talking about. But you
Yeah, 'cause
just
they won't
say
even get you to. They won't even let you get the pool and the servicing agreement no more either.
on seccinfo.com.
Well, no. When I requested, like for the clients that I work with, when I request the pooling and servicing from the mortgage company and the bank, they don't they fight me to give it up, and they used to just email it straight to me, but now I can't even get I can't they won't give it. And then when I try to do a discovery hearing, they push back on the discovery, and then the judge tried to sidestep it every single time.
So you put in a subpoena ducis tecum.
Yeah, I tried to. I put in a subpoena requesting the aspect of evidential hearing to get the pooling and servicing agreement, because when I tried to reach out to the mortgage lender, and then sometimes I even run it through the title company, and they now I mean they go acquiesce, and I give them notice under a notary, and then I put that in. But then, like you said, under the courts, the judges will sit there and just act like they don't
You
see
have to
nothing.
establish relevance first. It has to be relevant, not unduly burdensome, not privileged information, and timely. There are reasons that someone can object with a request for productions of subpoena ducis tecum. So you have to establish relevance. Typically, is the number one thing, but you have to establish relevance first. So if you're the plaintiff, you need to organize and structure your pleadings and factual allegations in such a way to where it would be pertinent and relevant and not off point. And if you're the defendant, still, same thing. You need to look at their pleadings or be able to at least make some argument as to why it's going to go to the relevance, and this is required in order to establish
No,
XYZ.
I showed the relevance to show that it was never put
Can I,
into the. Go
can I
ahead.
tell you something? I'm going to tell you this. I did mortgages for 3 years, and there's a reason I don't do it anymore. Okay? There's a reason I don't try to fight mortgages or do any of that anymore. I started off my career for the first 3 years fighting mortgages. Let me say this. First and foremost, they are not going to allow any process to come in that's going to get everybody's mortgages free and clear, because when they had the robo-signing debacle back there in 2010 through 2013, that should have cleared almost half the country's mortgages right there. They killed that. They killed the rescission. They put a statutory cap on that of 3 years.
Yep,
Right?
sure did.
The rescission of the mortgages. They did that back in the day when I was doing it. A lot of different things and changes that they made. They're not gonna, the banks run that behind the scenes. I'm gonna tell you straight up. The banks run that behind the scenes. They ain't gonna let you come in there with nothing. I'll tell you this, I'll give you this though. If you want to find something that's really effective, get on Pacer or something like that and try to find cases that were settled out of court.
Okay.
Those are the ones you want to look at. You want to look at the pleadings of those cases, ones that have been settled out of court, because that's when you're gonna get some valuable information. Because if you force the bank to settle out of court, you had something.
Right.
But they didn't sell our courts. You didn't have anything, and that produce the note shit don't work. We were doing
No,
that back.
I never do that because I know that's a waste of time.
Yeah, that's
I
a
already
waste of
know that.
time. We did that like, man, we did that,
I
and then
be, I
also
be, I
really
be
the
looking.
securitization don't work because you could get the B424 prospectus and the insurance information off
Right.
seccinfo.com. You know, you pull up the B424 prospectus, it have all that information associated with it.
Because half the title company, they're not even registered to do business in the state, and then they don't even have a registered agent.
They don't, and a
even,
lot of
yeah,
times though, the mortgage origination company, after they come in, originate a lot of mortgages, and then they go out of business
right.
and sell them and sell it. You got they all do that. They all do the same thing. The mortgage originator, about a year later, that company.
Yeah, because long as they trading on the market, I mean, and then they securitize it, they don't care because they cash out on it. That's why they put the 90-day insurance policy against the actual loan, and then they loan out the rest of the money because like under modern money mechanics, I mean, it all laid it out right there.
Well, I mean, if you want to really understand it, I would look at FASB, the Financial Accounting Standards Board, statement number 95, statement number, I think it's 105. There are a couple of because you're talking about accounting,
Right.
and then also the insurance. Yes, all the mortgage. I can confirm what you're saying. They all are insured. I even had a drink with a banker that explained that to me. Like, we don't never lose money. They don't ever lose money or anything like that. I agree 100%. But
Right.
it really wasn't any money that exchanged. It was an exchange of credit.
Right, credit.
There isn't any money.
It's
That was
basically, not money. Yeah, you're right. Not
it was
money.
an exchange of credit.
credits.
In that you have to use what is called the matching principle, and that gets into all that accounting. But I'm gonna tell you like this: you can't confirm any of that unless you can bring in somebody in who's an expert witness that can attest under penalty of perjury to what you're saying. Or you have some sort of
I
verified
try to
evidence.
bring in the I do the forensic audits, and I try to get the forensic audit on the accounting done
I don't
as well.
understand what is the relevancy, like he said, to that when you bring in the forensic audit. What is it
Because
that you're trying to bring in?
it shows the break between the title and then where the trading and
Them
then what.
arguments ain't gonna. Them
Why
arguments
is
ain't
that
never work.
relevant? Like that's extremely key to understand. What I specify factual
It's
allegations on the pleadings
relevant.
for.
It's
Hold on,
relevant
brother.
because
Let me hold on. Let me
okay,
build with you. The
okay.
reason I'm asking, I'm pressing about the relevancy is because we kind of draw this parallel between what we know and what we think something should be, and the actual facts of the case. That is extremely important because that's actually all that matters. That's what brought forth the action. So when you're talking about showing a split between the title and all this other type of stuff, none of that really matters unless that's the basis in one of their factual allegations. That does not become relevant just because you believe it goes to show something outside
No,
of the factual allegations.
No. When they try to say they have equitable ownership within the property itself, yes, you got it
Was that in the pleadings?
yes, they put that in the pleadings that because they signed the mortgage, it gave, I mean, and you gave them, you gave them security interest into the property. They try to go in there and make the
That's
claim that
never
they have.
explained in the pleadings. That's not what typically explained in the pleadings is such and such entered a contract on this day with such and such. Such and such fulfilled obligations up until this particular date. Such and such transferred or received an assignment or transference of deed to substitute trustee or whatever it is. They'll say that, but they're not going to specify we got a security interest in something. We have equitable ownership. That's explained. That may be evident if you understand what getting an assignment means or is supposed to imply, but that's not on the pleadings.
Well, I'm saying they
I
don't
agree.
they don't come straight
I
out.
read these shits day in and day out.
They don't come straight out and say it, but they
And
try
that's
to
my
say
point.
based on the mortgage. But they say based on the mortgage, they're trying to say that they have ownership based under the contract, which they don't because you already did it under fraudulent pretext because
Hold on.
they didn't fully
Let me give you
disclose the
some.
information.
Let me give you some. What state are you in?
Pennsylvania, but I mean I work with other people in other states.
Okay, I understand. I'm gonna give you what I did. This is 10 years ago. What hit me to something, there was a case in Georgia by the name of Egana versus HSBC. It's Egana versus HSBC. EGANA, Egana versus HSBC. This is why you read case law, because the judges will give you answers. All right. So in here, what they did was they told me you had to put in an affidavit of forgery.
No.
Okay, because when you bring in this, but what they're going to do is they're going to do an administrative process. They're going to put an ad in the newspaper. They're going to go do all that, and then when they come in, they're going to try to tender that, bring that into evidence, proffer that into evidence, because that's all the attorney has firsthand knowledge of. They went and hired an attorney. The attorney's firsthand knowledge is just of the administrative process that he conducted. He doesn't have firsthand knowledge of the origination of the mortgage or anything. He can't attest to the penalty of perjury under none of that. Right. So the thing is, if you want to bring title into issue, you have to state, first of all, that the proper response to a dispossessory is there is no landlord-tenant relationship. Y'all put that in Chat GPT and see if I'm right. Is the proper response to an unlawful retainer or a dispossessory that there is no landlord-tenant relationship? Because if you're going to bring title into it. And then if you go, and then you got to put in it to the best of your knowledge and belief that the deed is a forgery. And now that's going to make them, they have to produce the original. See, because when you challenge a copy, then you force them to bring, then you should have some statutes in your state that will confirm that a copy is admissible if it's not objected to, as long as it's not objected to. Once it objects, and you object. I have all the code sections here in Georgia. I don't know about other states. But what I do know is that once we discovered that, they rescinded the code section for the affidavit of forgery in Georgia. And this is what I'm telling you. Everything that we found out that we could do, because like if you read your mortgage, it says that you guarantee that the property is seized. Seized means you said you own it.
At one point in time, yep.
But how do I own it and I haven't bought it yet?
because what they don't tell somebody here is that technically when they run your credit, that the credit already totally pays the whole
Well, this
thing
is
off.
wait, hold on. This is before any credit or anything. And I had the top real estate attorneys in Georgia. I was working with all of them, and I'm gonna tell you what he told me. He said, "You're absolutely correct, but they'll never let you bring that into court." He also told me, because back in 2010, when I was doing this, attorneys were working with us. We were doing civil action lawsuits and everything. And but if you get on the internet on YouTube, put fraud closure in, you'll see attorneys on there talking about this fraud that's going on. Right. You can't find a single attorney to help you right now, because that attorney told me, we got the call, we can't help y'all anymore. And that was around the time of that robo signing. So they killed an attorney. Yeah. You can't find an attorney nowhere that's going to help you with a foreclosure.
Yeah.
I'll be remiss if I didn't mention this about Egana versus HSBC. Because what's important about that is dude was making an argument that the court erred in allowing that document. And like Yusuf said, the judge taught class, right, and said, well, what you should have done, according to this statute in here, what you should have put in an affidavit of forgery. But here's the thing. You know why they didn't accept that at any point in time afterwards? This is why being courtroom competent is essential. Because the evidentiary phase was closed at that point in time. When it's time for trial and it's time to litigate after that, the facts closed, the pleading stage closed, the evidentiary phase closed. It's done. Now it's time to have a fact to try the facts. That's what that is now.
Yeah, well, this is the appellate court, and they weren't doing a de novo review of the case. They're just looking for procedural errors, and this is what they're identifying right now. But the thing about it is I understand that. You're absolutely right, but I read case law because you learn more when people lose. Because when they lose, the judge will tell you what you should have done.
Right. But I was making that point, right? Because we have to really understand we can't just stay on theory. You need both. You need the commercial science understanding, and you need the courtroom competence.
You got to read case law. You got to read case law. If y'all really want to know the law, y'all got to get into reading case law.
But would you say now, Yusuf, like back in the day they used to explain it, but now they're like trying to go around it because they know more people are now tapping more into reading the actual decisions from the judges. So they're
I don't know. I haven't done a foreclosure case since 2013. Okay. But I'll say this. From back in the day, I'll just tell you what they did back in the day, and you tell me what they did today. Back in the day, what they did was, first of all, in the pleading, they would list the name of the trust. They stopped doing that. And they put the servicer in there now. But they would have the name of the trust. That would be on the pleading.
Right.
And they stopped that. We didn't have to look up anything. They would give us the name of it. And then people start, that's when securitization audits started and all that, and TILA and RESPA violations.
Right.
And I only know one person that won a TILA violation, or TILA and RESPA violation. He was an attorney out of Tennessee. I drove up there and talked to him. He's the only person I know that won.
Right.
He's an attorney. And so everybody was losing and stuff, man. And while they were losing, first of all, it started with the produce the note argument. You know, they separated the note. Everybody was doing the produce the note arguments. That wasn't working. And then they went into rescission. Okay. Then they put a cap, a 3-year cap on that. But you had to have certain notices that were supplied to you in your mortgage paperwork, even for that to be effective. They stopped doing that. And then people were doing removals and bankruptcies and all kind of shit, man. I watched them go through different iterations of that mortgage foreclosure process that they didn't. Let me just tell you this. You're not going to be successful in any large capacity where they're going to let 1 million people walk through the door and they all going to get their house free and clear. That's going to never happen.
Oh, no. I mean, of course, I'm not saying everybody. No.
You gotta come with some strong evidence. You need to have some witnesses and things like that. And if you don't have that, like, for instance, the guy who made Tom Schaaf, he's a CPA. He wrote that book, The Banker's Secret Manual. We talked to him and his people. He used to go in there and serve as an expert witness because you would need an auditor who audited a bank. And he used to audit banks.
You will need ledgers. That's that whole accounts receivables and payables everyone talking about, because when he was, just like what 9 Ether was talking about earlier with the Treasury not being a bank, that's show the fuck right. But with financing, there has to be accounts getting accounted for. There has to be ledgers.
How's the Treasury not a bank?
By definition, per the UCC, it's not considered a bank. It's a financial institution.
It's a bank for the United States.
It is.
It's funny. I got an account
right now.
Wait, hold on. I got an account with the Treasury Department, and every month they take money out of my account for taxes.
For sure. It just doesn't satisfy the definition of a bank. For whatever reason, they make a distinction between financial institutions.
It's a financial institution.
Yeah, exactly.
It's a financial institution. All right, that's what it is. Bank is not even the term you're looking for. It's financial institution is the term.
Yeah, exactly.
The only time the bank element is relevant, my father cut your belt and say this real quick. The only time the bank aspect is relevant is when people attempt to say they're drawing on the Treasury and they're still tendering a money order or check, which have imparted in their definition drawn on a U.S. bank. So if you're drawing on the Treasury, you're not drawing on a check. It's not a check or a money order. That draft is a different type of draft. It's not a check or a money order because it's not drawing on a U.S. bank. That's
right here under 31 USC 5312. All right. Here are the definitions of financial institution. An insured bank, a commercial bank or trust company, a private banker, an agency or branch of a foreign bank in the United States, any credit union, a thrift institution, a broker or dealer registered with the Securities and Exchange Commission, a broker or dealer in securities or commodities, an investment bank or investment company, a currency exchange or a business engaged in the exchange of currency, funds, or value that substitutes for currency or funds, an issuer, redeemer, or cashier of traveler's checks, money orders, or similar instruments, an operator of a credit card system, an insurance company, a dealer in precious metals, stones, or jewels, a pawnbroker, a loan or finance company, a travel agency, a licensed sender of money, or any person who engages as a business in the transmission of currency, funds, or value that substitutes for currency, including any person who engages as a business in an informal money transfer system or network of people who engage as a business in facilitating the transfer of money domestically or internationally outside of the conventional financial institution system, a telegraph company, a business engaged in vehicle sales, car dealership, dealership.
Oh, wow. Yep. Well, I got mute they mic.
Persons involved in real estate closings. Look at you. A person involved. What is that? Explain that to me, 9 Ether. What's a person involved in a real estate closing?
That would be the consumers. That would be the consumers looking to get a home loan. Right there at the closing table, to say that you execute those documents, you are facilitating commerce as a bank.
Okay, so there's some sort of financial institution at the closing table.
Absolutely.
Yeah,
Okay.
because they're transacting when they looking for that money to be in the escrow
It,
accounts.
Well, no, you signing a promissory note and you're making a
correct.
deposit.
That's exactly what it is. I can quote it verbatim. What they do when they make loans is not to, they don't extend any of their reserves. What they do when they make loans is to accept promissory notes in exchange for credits on the borrower's transaction account. And it says that the reserves are remain unchanged, but the promissory notes constitutes an addition as in deposit. So that he's right. You execute a promissory note.
And you should look up the definition of deposit too. An
Law
agency of
deposits.
the United States government or a state or local government carrying out a duty or power of a business described in this paragraph. A casino, they're a financial institution. Any business or agency engaged in any activity which the Secretary of Treasury determines by regulation to be an activity which is similar to, related to, or a substitute for any activity in which any business described in this paragraph is authorized to engage, or any other business designated by the Treasury whose cash transactions have a high degree of usefulness in criminal, tax, or regulatory matters. Now, back to what he was just saying about utilizing the bills of exchange and all that. See, that's a private matter. That shit don't have nothing to do with the public. That's where a lot of y'all go wrong. That is why you send, all this is supposed to be done privately behind the scenes. There's a reason that the Secretary of Treasury never send you back any of your bonds, anything like that. They can monetize. I've talked to bankers. I had this banker, he tell me this one time. He said, you know what? I used to have a bank and he said people would come in to the bank and try to cash fictitious checks. You know, they fake checks. I'm sure all of y'all know what I'm talking about.
Yeah.
Okay. And he said, what I used to do, he said, it'd be in my office. I'd be looking at the check and they have a fake ID. And I say, and all of a sudden I get up and tell them, I said, get up out of here. This fake check, I'm gonna call the police. And he said, they'd get up and run out of the bank and leave the check behind. And he told me, he said, I used to go to the Treasury window and say, we have abandoned funds here. He said, it has a signature on it.
Shiesty. Shiesty.
Your paper.
Yeah.
He said it has signature on it. They monetize that stuff. Ask yourself this question. Fraudulent check fraud is still going on to this very day. Why have they stopped it?
Because
The UCC allows
They don't
for
want
it.
to. It benefits
it's
them.
just
The
not
UCC
registered.
allows for
That's
fraud.
it.
The
Because
UCC
have
allows for fraud because if you receive a negotiable instrument and it looks good on its face, has a signature, date, and everything, there's no indication of apparent forgery or anything like that, and you don't have notice that it is a forgery, you can negotiate that to somebody else.
you constitute a person entitled to enforce it. Yep.
So I thought that just for banks they could do that, but then if a regular
No, anybody can do that.
You do that every day. It's called a buyer in the ordinary course of business.
Anybody can do that. See,
Go and
this
look that
the
up
thing.
in the
This is what I
UCC.
want to. This I'm gonna say to y'all. This is a game. Okay, if we're gonna play Monopoly, I'm gonna ask a question. What do you do in a game of Monopoly when the bank runs out of money?
Take sheet of notebook paper out, right on it.
Okay, now you know how you know that. How do you know that?
To keep it all the way a band with you. I'm not even gonna lie to you because you said it on YouTube once, and I went and finally read the rules after that. But then, what should have been is I should have read the rules when I was 8-9 playing. But I'm not gonna lie. It's because I heard you saying on YouTube. That's why. That's how I know. I ain't
Okay,
gonna lie.
so my example is there are rules to the game. If you're gonna
Right.
deal with negotiable instruments, read the goddamn rules.
Right.
Y'all ain't gotta be ashamed. Don't act like y'all don't know that because y'all
Read the
read the rules.
rules.
Y'all know that because y'all saw the same YouTube video I saw. Go on, keep it there. OG put us on, and that's how we know because we ain't read that shit we got called out for. Y'all ain't
Y'all,
read that
if you
shit.
want to talk about securities, that's Article 8 and Article 9 is secure transactions, and Article 3 is negotiable instruments. Those are the three articles in the UCC that you should focus on more so than anything else. Right? That's what it is right there. They got enforcement, everything. If you're going to play that game, there are rules to the game. You can't make
Right.
up your own shit.
Right.
I
Yeah.
would also like to add in Article 4. That's a very slept on article. When you
Man,
talk about
Article
what
four
you
is
have to do.
Article
Articles
4
1 through
is too.
9, man. Learn
I
the
mean, yeah, but like
definitions.
typically what we talking about when we talking about
Yeah,
enforcing, if you're
specific to what
tendering
we're
something,
talking about.
Nah,
yeah,
yeah. Like I get to specifically what y'all talking about as well, but also these folks got to know these definitions of these terms.
Yeah, I agree with that.
Like, man, they
agree.
go through that one. You won't feel like you did yourself a disservice just reading through the whole thing, man.
And then
And let me give
I
y'all
got
this. I'm gonna give you this. The
the
words
bulk
you use
transfers, we don't need to know that.
The words are so important. The words you choose to use are statutory triggers. I just did a video on YouTube because this is what happened. I was, I do private trust. So I was hearing everybody talk about fund to trust. And I was like, what do they mean fund to trust? I'd never heard that word before, not in the private world. So I did some research and I said, oh, attorneys use that term. But there's a reason we don't use fund a trust on the private side. It's an exchange. It's called an exchanger. You exchange property into the trust. You don't fund a trust. Okay, not on the we don't use the term on the private side. So I was researching with ChatGPT, and it said if you use any term that has a statutory definition associated with it, that automatically triggers statutory jurisdiction. You shouldn't have any. So I did a video, gave y'all 50 terms that trigger a statutory jurisdiction, and it's right there on YouTube. And I gave nobody can watch it. That should have 1 million views. But don't none of y'all know that, do you? But that, you know what? Thank you, ChatGPT. It said, because it said, you know what? Yeah. I said, this triggers a statute. These are statutory triggers. The first thing it goes through is the terminology you're using. If you use any word, you should stay away from any word in a private process that has a definition in a statute. There's an alternative word to use for every word. You shouldn't use any verbiage that has a statutory, because as soon as the judge sees it, they're going to automatically use the statutory interpretation. It automatically invokes statutory jurisdiction. You learn all of this. If y'all study, I'm going to tell you this, the best way to learn all of this is study private trust. If I had to do this all over again, that's where I would start. I would start there, because that's going to teach you taxation. It's going to teach you the demarcation line between public and private. It's going to teach you how to maintain privacy, how to conduct your affairs in a private way. It's going to teach you all of that right there. You'll get a good idea of what constitutes public and what constitutes private, because that's the main thing with all of y'all that I see. The majority of people, now I say 99% of y'all don't really understand. Y'all use the term private, but you don't really know what it is. You don't know what public is either. You don't know what it is. And I'm gonna leave you with this. Private rights start where public regulation ends. That's the demarcation line.
I got a question.
Private rights begin where public regulation ends. You can't assert a private right in a public regulatory activity. You can't do it. You mixing public and private does not mix. I can't tell you, I've read probably 100 cases talking about that. They don't mix, man. Y'all better, that's the main thing. That's the number one thing I see is what an issue is. You think you have rights in the public that you don't have. And you'll try to interpret, like when we talk about discharging debt, you'll try to interpret that through a statutory scheme, and you can't do that. You can't interpret anything private through a statutory scheme unless that private person invokes it. And if you invoke that, then it's going to get reinterpreted through a statute. That's why I say it, private ordering. You need to throw most of this shit y'all studying in the trash and reorder it. And under that, to understand, you got to start with what's public and what's private. You also have to respect the public, because they do have a delegation of authority derived from the state and federal constitutions, respectively. All right, so they have authority. They have plenary power when they act in the ambit of their delegated authority. Pick that word up. It's called plenary. Plenary power means all powerful, not subject to any outside authority. You walking around saying, I'm the sovereign, we got the power. That is not true. That's a lie. And it's never been true in any country on planet Earth. All law is either public or private. They don't even use that word sovereign. They use public and private. You go back to the 1800s. That land grant to Louisiana, it was called the Heirs of Henry Turner. That whole case turned on, was it a public grant or a private grant? And the Code versus the United States. I can go through a number of them. It's public and private. Once you do what I'm telling you to do, you're going to start looking at them cases different. Your eyes are going to be open. You're going to see it from a totally different vantage point. You're going to have an epiphany. You're going to see everything differently. if you start right there. Because a lot of people, you know how I know a beginner? They quote a lot of statutes. That's where a lot of people be, 12 USC 411, 18 USC 271 and 272, conspiracy against rights. I'm going to do a Title 42 action. I'm going to do all that. You saying all of that. You haven't learned the difference between public and private yet. You're supposed to be dealing with contracts. That's what private people do. We deal with contracts. And contracts is based off an agreement. And there's no statute that has any authority over that. Because what? Article 1, Section 10, the contract clause, they can make no law that will impair the obligation of contracts. As long as those contracts are drafted and they don't violate public policy. That is one of the tenets of trust law too. Trust law is also your indenture agreement. You can mold a trust in any form you want to. It just can't violate the doctrine of perpetuities, as well as the fact that it cannot violate a public policy. But anything else, you can draft it how you want to draft it and make it up, as long as it follows equitable rules. And like, for instance, if you got an irrevocable trust, there are certain features that trust must possess in order to be considered irrevocable. One is that the beneficiaries cannot exercise any type of influence over the trustees or the trust corpus, and nor can the settlor. As well as the fact that, there's a couple of other things as well, but, you learn those distinctive characteristics that have to be highlighted if you're going to go into an equitable court and have something adjudicated. But your remedy is always in equity because you're dealing in contracts. So equity, and God judges with equity. Equity is fairness, impartiality, and even-handed dealing. That's how we're supposed to be dealing with each other. That's why equity governs us on the private side. It's equity that governs on the private side. Statutes, codes, rules, and regulations govern on the public side. So equity, equity there to adjudicate contracts and trust and things like that. Equity, and you need to be studying equitable principles, contracts, and private trust. That's where the focus of your attention should be. Even when you're doing that secure party process, what you're trying to do is establish a private agreement with the Treasury Department, not a public agreement. It's a private agreement. It's private. You can't interpret private processes through public statutes. Now, a lot of guys do that and make that mistake. Public and private don't mix. You can only do that if you bring it into a public space. And that is why one of the rules is do not participate in public controversy. There is a word you can look up. It's called a public figure. You get a Black's Law Dictionary. A public figure is anyone who voluntarily participates in a public controversy. When you end up in court, you're in a public controversy. That's why Rupert Murdoch just settled out of court. He took his private matter into the public. And that was a mistake. That was a mistake. Man, everybody was trying to get that case. Pull that case up right now. Rupert Murdoch tries to amend his irrevocable trust. It's all over the place. And he wasn't able to do it because you can't do it.
What made him do that?
Read case.
Because his son, he had left his son in charge as a trust. I believe he's a trustee of it. It's irrevocable, so he can't amend it. But he was trying to amend it. And you got to have a good reason to amend an irrevocable trust. And that has to be articulated within the tenor of the indenture agreement itself. If it's not in there, and the way that has to be done is specific, meaning like, for instance, with 100% from the beneficiaries, they have to agree to it. If you have a trust protector in place and he agrees to it, and then maybe 2/3 of the trustees agree to it, or 100% of the trustees agree to it. You have to have mechanisms in place to amend a private trust. But anybody wants to get their hands on a private trust of that caliber because he's a billionaire. So you definitely want to see how he planned his estate, but they keep it private. They don't want you to see all of that because trust me, those are some of the most elite trust indenture agreements that you can read.
So let me ask you this, Yusuf. If somebody ran bankruptcy of a mortgage through Chapter 7, what would you say on that?
Chapter 7 is liquidation. You don't want to do that, man. Let me tell you something. I've done those with people, with clients, and that's a liquidation. And so they arrested the client because he wouldn't come to court. And they had his ass arrested and brought. He made me a trustee, and I actually went in court and talked to him. But when they liquidate that, you're asking them to sell all your property to pay the debt. Let me tell you the best thing in a bankruptcy is when you file bankruptcy, do maybe a chapter 13, a reorganization, not a chapter 7, which is a liquidation, and do an adversarial proceeding because they issue B10 proof of claim forms to all the people who are the creditors. And when they have a meeting of the creditors, and you need to do an adversarial proceeding, and that's a good place to do a challenge in bankruptcy. And an adversarial proceeding.
When I did a chapter 7 and I challenged it on two other cases, and I told them through the trustee, I had already laid out that the violations that we saw within it, and there wasn't nothing to be liquidated in it. So basically, after I broke everything down, then he signed off, wrote the report to the judge, and told them, listen, there's nothing here, whatever. And me and him, was going back and forth having that. He looked.
Wait, hold on. What did you find? Why did you file a chapter 7? Was this on a foreclosure or?
Yeah, this was on a foreclosure.
Okay, and he said that, you didn't have any property to liquidate. Well, yeah, you didn't have any property to liquidate. So how are you going to pay the debt? I mean, the point is that you filed it so, you can have somebody. When you file bankruptcy, that's a public declaration that you're incompetent to handle your affairs. So you're asking your property to be placed into the custody of a trustee. And that trustee is now the one that's in control of all of your property. And, he's going to ask you everything that you got, and they want to liquidate that so they can pay the creditors. But if you don't have anything, the court is probably wondering, well, why did you file a chapter 7?
To get the lien off of it, because when they
that's not going to get a lien off of a property. That's not going to get a lien off of property, brother.
No, it came off because he wrote it and said that it couldn't be liquidated. Then we moved it in the trust because he already made.
You're saying that they removed a lien off of a mortgage because you filed a Chapter 7 bankruptcy. Is that what
because there wasn't nothing there to satisfy on it. So
man, let me tell you something, man. And between 2010 and 2013, that's all everybody was doing was filing bankruptcies. That's what everybody was doing. I ain't never heard that.
I could send you.
I ain't never heard that.
No,
I think you may have filed bankruptcy, and another mechanism might have had some lien removed, and you might just be attributing that to the fact that you filed bankruptcy. But a bankruptcy.
I can send it. I can send it to you. I just need your email. Just send me your email. I'll send you.
I'm not sitting there trying to act like I know everything because that's a maxim of law. Many men know many things. No man knows everything. Don't nobody on this call right now know everything. Right. I'm just giving you my experience. I got a lot of experience in dealing with it.
I got you.
So people filed plenty of Chapter 7s and Chapter 11s and Chapter 13s back in the day to forestall a foreclosure. Everybody was doing that. As a matter of fact, it was very effective back then because you could stay in bankruptcy like 2-3 years, and people was doing stuff back then, but they didn't cut all that down now. Back in the day, we would do removal. You could do a removal of a foreclosure back in the day, and that shit would take almost 9-10 months for them to get to you.
Right.
They don't do that no more. They kick it back in 30 days now.
Cause see, the fundamental thing that the trustee was trying to look for was, well, what's the reason why? So when he pulled the case file of what we was disputing in court versus what the assets was, he said they should have released this already. He said because there was no asset to be there, and due to the fact that we notified the Security Exchange Commission and whatever, and they already was already under investigation, because when I was talking to the trustee, and then they pulled the Department of Justice, and then they ended up looking into it, and 2 weeks later said we're releasing this because she said, first of all, you already got the case open. And now it was exposing that it wasn't in the REMIC in the first place, because half the mortgages never go into the REMIC anyway. So when
hold on. Well, where are they going if they don't go in there? What do you mean they don't go in there?
No, they just either destroy them because they never place them into the REMIC at all.
Wait a minute, hold on. That's what MERS is for, the Mortgage Electronic Registration System. That's the argument we were making back in the day, because they got something called a true sale. Have you ever heard that term, true sale?
Yeah, I heard of it.
Okay, true sale is a securitization term. that is what the issue was. Is it a true sale? Once you do that mortgage and it transfers over to that servicer, and he's going to put it in that real estate investment trust or this REMIC, in that vehicle, that investment
Right.
vehicle that you're talking about. Is it a true sale? Meaning, what rights are retained by the mortgager and the mortgagee? What rights are retained by those two individuals? And you retain the right of set off. That's called the holder in due course rule.
Due course.
And the Federal Trade Commission is the one that promulgates that. So now, where did I get all this? I got this from the American Securitization Council when they wrote an exposure letter to the Financial Accounting Standards Board. The chief of that, his name is H.G. Wright. I think he may have passed away by now. But I'll give you all that information you want. I did a deep dive into all of that stuff, into securitization and the insurance. Yeah, they are insured, and the insurance does pay them off. Everything you said is correct. That's back in the day. But how are you going to get that? How are you going to make that relevant to the fact that you didn't perform on a mortgage, on a contract?
Well, the fact is that if you look at it though, when you sign the mortgage, they're not telling you that the deed of trust is the actual owner of the property. So when you sign the mortgage, you're signing over your rights to the mortgage company to then become a tenant. So by that portion, you're misrepresenting the terms of the agreement.
Can I ask you a question? I'm gonna tell you what an attorney told me one time. He said, I've been doing mortgages for 10 years. He said, I've never had a single person read their contract.
I know. I can attest to that. Yo, I tell people this all the time, and they like, I ain't got time to. You better read that damn thing.
Let me tell you this: you got waiver of rights clauses all through that damn thing, man. I mean, I don't.
Right.
When you actually read it,
yeah, I get you.
Did you read before you argue with these people? Mm-hmm. Did you read I'll give you an example. One time, I'm gonna give you an example of something. One time, I had Airbnbs. I had a lot of Airbnbs, and so COVID had just kicked in, and what I used to do is every time I opened up a new Airbnb, I would go get buy the furniture for it 90 days, same as cash. Okay, so I would get it, furnish the Airbnb, and in the first 3 months, all the revenue that came from it, I'd pay down the loan, and I'd always pay it back before the 90 days expired. Okay, so one time I did it, and I didn't pay it back before the 90 days expired because I kind of got thrown off because of COVID. And I kind of was kind of curious as to what would happen if I didn't pay it back in the 90 days. So it was about $3,600, all right? And I paid it down to I'd paid like $2,800 on it, and I owed about $800 left when the 90 days came around. So next thing you know, they wrote me, say I owed them $9,600. I said, what? I said, I'm like, after it went over the 90 days, it went up to $9,600. I'm like, whoa.
Yeah, they called that
what the fuck is going on? So I did what all of y'all do. I was calling them, cussing them out, got on the internet, went to the Better Business Bureau, found all these people complaining about them and everything. But then I stopped and I said, let me read the contract.
Right.
I read the contract, and everything they did was right in the contract. But here was something else was in the contract. It said that after the 90 days, I can choose if I want to terminate the contract and return all the furniture, I could. I only paid $3,600 for everything. It's cheaper for me to give it all back and buy something all over again new than pay $9,600. I said, shit, I just give y'all this shit back and go buy some brand new shit and still come out on top. Right, that's how I was looking. So I called the company. I said, the finance company, I said, look, man, I need you to come and pick up this furniture. And it was like, no, sir, it's COVID right now. It's COVID. We can't come and pick it up. I said, I don't see any hazmat clause in this contract that specifies in case of some sort of pandemic, we reserve the right not to pick up the furniture. That is nowhere in this contract, sir.
Right.
He said, well, we're not picking it up. I said, well, are you going to keep charging me? He said, yes, we are. I said, okay. I didn't argue with the employee. Because I see I'm dealing with somebody that doesn't understand who they fucking with. So what did I do? I said, okay. I went to LinkedIn. I found the CEO of the company. I wrote a letter to him and I sent it to his message on LinkedIn. All right. Then I wrote him a letter, certified mail, with an affidavit of mailing also. And this is what the letter stated. You are hereby noticed that you are, and I put the clause in the contract in there, that you are, that I am demanding that you pick up this furniture, and I no longer am desirous of, of keeping the furniture. You can have it back. I forgot the exact language I used.
Right.
And I said, from the receipt of this letter, every day I have the furniture, I'm charging you for storage, $200 a day.
Right.
Their counsel called me and said, "Sir, you can keep the furniture, no problem. Keep it." I'm only saying that to say to you, that's the power of reading the contract.
Right. Exactly.
Instead of, I was about to do all this stuff everybody else was doing. Oh, these motherfuckers fraudulent. Blah blah blah. And let me give you another bit of information. The Better Business Bureau is an excellent place to conduct an administrative process. Because the letter I wrote, I also filed that with the Better Business Bureau. The Better Business Bureau is going to send them a notice to respond to it.
Okay.
And see, they got to respond to that. And so it's going to give them a time limit. So I'm covering all my bases. I'm sending them notice. I said I filed it with the Better Business Bureau. I sent it to them on LinkedIn, and I sent a certified mail to let them know that every day I got to keep this furniture. After this notice, I'm charging your ass.
Would you send it to the CFPB too?
Anybody?
Yeah, you could. It's a consumer credit contract. Exactly.
Right.
What he putting folks on with is for real. Like that, they're regular agencies for these participants who choose to associate with this form of business.
I'm
telling you, the Better Business Bureau is an excellent place to conduct an administrative process, because if they ignore you, there's the record right there. What better place to have a record than the Better Business Bureau? You write a letter, they got to respond. The Better Business Bureau going to send it to them and tell them to respond.
Right. Yeah.
And so if you're going to do a 15 USC 1692 G validation of debt request, all of that kind of stuff. Yeah, you can do that through the Better Business Bureau. I discovered that when I went through that process with that company. But my whole point in bringing it up, why are you arguing and you haven't even read your contract? You should never put your name on anything that you don't know the meaning of every word in the document.
Right.
No, that's for real.
I agree.
One thing that my dog seen was
I agree.
that a lot of this sovereign citizen stuff that people saying with the signature creating value and things of those nature. Wait. But it's a method to this madness that I'm telling you, right? So that's one of those, conversations. So he wrote a letter to the Office of the Comptroller of Currency. When they investigate, they're going to investigate. Just like what he said about the BBB. This is the OCC. This is who is a Treasury enforcement agency, and they are a regulatory department. So when they do their investigations, they get everything associated with the account. So in the letter he showed me, and this is why I said definitions are important, and why, even though I threw that out about the whole UCC, like, I get some of these things are big to digest, but you want to arm yourself or, have your shit sharpened to the teeth to where you can be able to, maneuver and know what all you are participating in. But when he read what the OCC wrote him, my dog was discouraged. And I'm like, what you discouraged for? Like, what did you write him? I didn't even read the letter, but he told me what he wrote him. I was like, nigga, that sounds like a lot of sovereign citizens. But I was like, all right, bro, what did they write back? So they wrote back to him, in regards to your question, the contract clearly states, I'm a motherfucker who understand, you feel me? Wait, you feel? So you caught it already. Like, the contract clearly states you grant a security interest in the account and the accessories, insurance, the automobile. I'm like, so they basically, and then at the end they told him, seek competent legal counsel. I was like, bruh,
Let me
What you
tell you
upset
something.
for? They told you what you wanted to hear. They telling you, yeah, you show the fuck right. We know banking and we know commercial paper. So you're sure right. But hey, from what we read, you gave them that shit. So
Yeah.
what is you crying about? You should probably
Yeah.
seek legal counsel.
No, see what happens is a lot of people when they say, "Well, you gave them the right," and then people will say, "Well, you know, under fraudulent pretext, you got under fraudulent pretext." But again, like Yusuf said, you got to read the details of the contract to make a legitimate argument. Because a lot of people when they at the closing, the trick is when you at closing, they got 300 to 500 pages, and they know a lot of people not going to take time to read that. You know
Yeah,
what I
but
mean?
you know what I did when I bought me a car? When I bought my Hellcat. When I was in there, I went straight out. He had the finance manager. I always carry one of those companion Black's Law dictionaries with me. Anytime I'm going to do anything like that, I got me a law dictionary with me. And when they hand me all that paperwork, I take my ass and go sit down and I read it. I don't give a damn how long it's going to take. And let me say something else.
Right.
With ChatGPT, you can upload a lot of this shit now. And as long as you know how to do the proper prompts, it'll tell you what to look for and identify things in it that you need to look for. My last car contract that I signed, I scratched out by hand a lot of things, and the finance manager took it because after reading, I'm saying, man, what is this bullshit right here? This some shit I ain't got to do. You know, I'm seeing shit in the contract. I'm reading like, what is this shit? No, hell no, man. What the fuck is this right here? They put all kind of stuff in those contracts.
Yeah, they do.
And you know, and that's why I said those waiver of right clauses, you need to pay attention to those because every mortgage contract has one in it. Like for instance, you got confessed judgment. Okay, that's how they come and get your car without taking you to court because there's a confessed judgment clause in every car contract. That's in the contract. That's why they don't have to take you to court. They just come pick up your car because you already confess judgment as soon the first day you delinquent, they can come and pick up your car.
And they list it, and what they don't tell you, they list it as a commercial vehicle already.
It doesn't matter. All that commercial stuff doesn't matter. All that doesn't matter. You know, that's not what's attaching jurisdiction. It's commercial or not. With an automobile, what is attaching jurisdiction is public safety.
Right.
Commerce is not. That's something else. That right to travel stuff. Y'all need to throw that shit in the trash.
No. I wasn't going. I wasn't going to go into that.
Shit in the trash.
No, I wasn't going to go into that. No, I was talking about strictly on basis of the car and the contract itself. Because when they make a taxable event, they put it under commercial, agricultural, or residential. So,
but I don't know what that has to do with performance on the. Okay, listen. Let me just say this.
I'm just talking about contracts.
Contracts, some of the most powerful things in law. Contracts. They some of the most powerful things. You sign a contract with God. It's called a covenant. You sign a contract with your wife. It's called a marriage.
Yeah, bro talking right now. Yeah, he talking that talk.
You can sell your soul to the devil
covenant
with a contract. You can sell your soul to the devil with a contract. That's what's happening in Hollywood and in the music industry. They selling their soul. Contracts are some of the most powerful things. And that's why I keep telling you, how you, as a private individual, you need to master contracts because they're a double-edged sword. They can work against you or they can work for you. But it depends on how you draft the contract.
Exactly. And one of the terms that I really tell a lot of folks about is executory contract.
That's an incomplete contract. It hasn't been executed yet. Executory contracts are contracts that have not been executed.
They got other agreements inside of.
Yes.
Just like how we got executive orders.
And see what people don't know is, even under unilateral contract, I mean, they also have an implied clause into it too, but it's also used as an implied contract even when you catch them. So they say, well, we're not plausibly responsible for being that.
Man, y'all really missed the gem he just said to you. He said that executory, when I said that those are incomplete, and he's so correct. The reason why is because they have inner covenants there
Right.
are still obligations that have to be performed on both sides.
Yes. Let me say this to you, man. The only remedy, when I first got into this, the only thing there was discharging debt. Okay, that's all it was. All right, that's how I came into it, and that was the only remedy. If y'all really study this, people have been doing this since the 1980s. This is how far this stuff y'all talking about goes back. It goes back into 1985, 86, even before then. And what in the beginning, what everybody was keying in on is the fact that there was no money. And that if it's a commercial system that is operating on it's a debt-based system operating commercially. And that was their Achilles heel. And that was the only thing we attacked. Later, I started noticing people, well, there's no money, so you didn't really loan me anything. That's what led into that. And then there was, a whole bunch of people started trying to buy things and stuff like that. But in the beginning, all it was really for a criminal matter. All it was the set off. So when I came into the game, I wasn't arguing that, oh, you didn't make me any loan. I wasn't arguing that you don't have jurisdiction over me or nothing like that. Everything was acceptance for value. Okay, that's what that came from, which is like in common law. That's like if a criminal case, you got something called a confession and avoidance. That's a common law pleading. That's what acceptance for value is. It's a common law pleading. But the whole thing keyed on there wasn't any money. Y'all have taken it into a lot of other places that is based off of don't have any type of basis in law of fact or anything like that, can't be substantiated, or anything like that. The only thing that you really can substantiate is that it's a debt-based system. That can be substantiated. But a lot of the other stuff, I'm just
One
looking at
thing
it.
as well, though, that you did say was value, and that's a form of an ancient practice. I read in the 1400s, it was families like the Medicis, but as well as the Vatican Church as well participated in the pledge-based system that was started in Kemet.
Yes, it goes back. Law merchant goes back at least 6,000 years.
Oh yeah, for sure. See, that's why, man, bro, you be dropping it, and
goes
you
back at
kind of
least.
shine light.
Yeah, they adopted the law merchant because when they went off gold and silver and went on negotiable instruments, that's why they picked up the law merchant, because that's what the law merchant deals with. It deals with, commerce overseas, deal with bills of exchange and all of that stuff was used in international commerce. So they adopted that system. That's why they say they adopted the UCC in all 50 states, but it's been adopted in every country in the world. I was just over in Germany, and some people from Poland who listened to me came and talked to me, and I had to help them identify where their UCC is. It's not called the UCC in other countries, but every country has some form of the law merchant within their legal system. Every one.
For
Because
sure.
all countries are bankrupt. They're all using dead paper. Europe is using it.
They all a part of they all
central
are in
bank.
a form of a association. Yeah. You sure right.
And the
Just like
central
how
bank.
when
And it's an agreement. It's like I don't want to call it a private member association, but it's an agreement. They all have agreed to operate this way.
Hey, Yusuf, can I ask a question real quick? I don't.
Yeah, sure.
I asked the panel once already before you got back up here, but I just wanted your opinion on it. I was doing my own expungement on a OP. Or OP is from 1990, and I'm doing an expungement on it.
Is it a federal or state?
It's I believe it's a state.
All right, go ahead.
But it's an old OP. You know what I'm saying? And I'm trying to see if it can be.
What is OP?
expunged.
What is OP? I don't know what that means. What's OP?
Oh, order of protection.
Okay, all right, go ahead. I got you. All right, go ahead.
That was my question.
So you're trying to get rid of the order of protection?
Either seal or expunge.
Well, you can get it expunged. I got a book on my website, how to expunge a record, because I don't know if that's criminal. I don't know what the
It was nothing done behind it. It brought up and it got it closed, and then nothing was in regards to it. Wasn't nothing. It was just it's on there. You know what I'm saying?
I can't tell you right off the top of my head. I do know this. I can only tell you this. The first thing you got to do is you have to get your jacket from the feds. So you're going to go to either like UPS or a sheriff's office. You got to get fingerprinted. You know, if you don't want to go to the sheriff's office, there are UPS that will fingerprint you. You get the fingerprint cards and get the fingerprints, and then you fill out the form that the Fed wants, and then they're going to send you your jacket. You got to get it to the feds. That's like having a credit report.
Okay.
That's the first step that you have to do to expunge it. Now, there was a way that dudes were doing it back in the day. Once they got that from their jacket, they would go through and bond each of the charges on there. And there's actually bonds that everybody uses on Scrib, but people just don't know what it is. They don't know what they're looking at. But that was one way. You can't do a federal charge, though, because you got to get only the president can do that on the Fed level. But on the state level, you can do it. I mean, a lot of people expunge you can expunge your records yourself on the state level.
Right. Because I know that they now in the county that I'm in or in the state that I'm in, the governor has already said that all cases from 1990 and on through is already up for expungement, where they're getting it off because they're stating that it's hindering people from getting houses or getting homes or getting, jobs and the things. So he's trying to make it where everybody can get all them old records up off of their background.
Let me give you a story that I have. I got a friend, he electrician, right? He went to prison, he did federal time. Okay. And you do time, it does prevent you from doing a lot of things, but let me just put a bug in your ear. He's a very good electrician, but he couldn't get an electrical license because, he had a felony on his record. And I told him, I said, look, man, why you want to get a license? Why don't you just, form your company and then hire a licensed electricians at the company and then let them do the work and you own the company. Likewise, the thing is, buying houses and things like that. Well, I'm going to buy a house through another means. Either I'm going to do it privately. There are ways of getting it privately, like through real estate investment techniques that you can get a home. There's a lot of different things you can do, alternative routes that you can take besides trying to go through the typical ways that everybody else does things too. Because the problem you're having is with your social security number. That's the issue, because everything is tied to that number. So when they run a background check on you or anything, they pulling up all this past history and everything. And that's what it goes into private ordering, own nothing, control everything. You shouldn't be having nothing done in your name in the first place. But I'm just putting that bug in here. But you can still try to, I'm not saying there's anything wrong with expunging your record, but people who are getting hindered, they don't look at your personal credit or nothing to open a business bank account. Mm. They don't look at any of that when you get a corporate lease.
Right.
They will ask you, okay, well, who's going to be staying in the apartment? You can put some people down, whoever you want to put down on there and everything. I've done all of this. I know what I'm talking about because I've had to, because I got a record.
Right. So that's why I'm trying to get it. That's why I'm trying to get it. It just doesn't look good for me and what my business is, and trying to get it up off of there.
You need to stop doing your business in your name.
Exactly, and learn corporate structure. One of my elders out here in Chicago got spanked. It was a white boy out here. Man, I'm going to call him a Caucasian boy out here that was grabbing property. It was during one of the biggest, mortgage crises going on in the U.S., and he was spanking people. Just like I said, it was people going through it, but it was people making a lot of money. And he was making a lot of money. So at first he did it to him the first time, but then he did it 6 more times. He grabbed him for 7 properties in total in the Chicago, Cook County area. And every time he came to get his ass, when he bought that debt from that bank, it was one of his companies, and it was named after different deviations of his name. One was the last name, Realtor Services. One was the first initial, last initial, middle name, and it was a firm. The other one was the last name in LLC. And that was all of his title getting expressed, showing the chain of title to which he got it from the bank. And man, my elder ain't know what the fuck he was doing. But corporate structure and knowing how corporations operate, corporate law is a part of the United States and English common law as well.
They tell you don't never put it in your name.
If you want to learn how to put, what I would suggest, a good person, his name is William Brocknick. He is an attorney and he's a real estate a guy, and I used to listen to him a lot. I got a lot of this stuff on SPC University too, because I went through a whole bunch of studying for real estate investment, and I can tell you this: you need to be using an LLC or something like that if you're going to be acquiring property. The thing about it is, the object of the game, man, is this: own nothing, control everything. That's the fifth rule now for me. Own nothing. Don't put, let me tell you what I did. The first thing I did is after I formed my corporation, I went and opened me up a business bank account. Then I called T-Mobile and I had my phone switched out of my personal name to my business name. That's the first thing I did. Okay. Then after that, I didn't have any personal credit. So I got a CPN number and I established me some personal credit on that. From that personal credit, I leveraged that into business credit. I went and got me a DUNS number, and then I leveraged that into business credit. Got me a Paydex score, and then I got a business credit. Once I got the business credit, every time I got an apartment or my Airbnbs and everything like that, I got corporate leases for that, which are very powerful. They're good to have. I got corporate leases right now. The best, I want a good apartment to get a corporate lease with is damn, what's the name of it? Camden, man, they do some excellent corporate leases. They are very big apartment complex, and they're all over the nation. If you want to do a corporate lease, if you got a Paydex score, you need to have a corporate resolution. You come in there with your DUNS number, and bam, and you got a decent Paydex score, they'll approve you for a corporate lease. Then I went and put my car in my business name. I got a corporate lease for that. And when I did that, they gave me the first time, it was a high interest rate. And I bit the bullet because I wanted to establish that. Then every time I went and did it after that, they gave me a great rate, everything after that. I only use business credit cards for all my purchases. When I fly somewhere, I use my business American Express card to get the flight. When I go there, I'm looking at some properties or something like that. When I go to the grocery store, that's slated as, providing necessaries for the business, for the maintenance of the business. Where I stay is in a corporate lease. Everything has to be, because anything personal, ownership is liability. You got to shift the liability from you to another corporate structure. That's what private ordering is. That's all private ordering is. Private ordering is setting up a structure to interface with the system with. They know none of you did that, so they gave you a default token. It's called an individual. You do an individual tax return. An individual is an entity. If you look up the definition of it, everything, all those entities, those personas are corporate in nature. They are corporate in nature. Even the individual is corporate in nature. But those are just devices they use to decide how it's going to get taxed and how they're going to attach duties and liabilities for conduct that is conducted in the public. That's what it's for. You got to understand the difference between public and private. Start demonizing these people. It's not that they evil, it's y'all ignorant. Y'all got to tighten up on your side before you attack these people. And you've been going off of a information that has been given to us from 30 years ago. This stuff y'all talking about is 30 years old. It's 30 years old, and it's wrong. A lot of it is wrong. And that's what God gave us. God gave us ChatGPT so we can take out all the bullshit. I'm not saying it's all bullshit. Not everything. There's some, because I went through this. I went through the criminal justice system. I seen what was going on. So I know that there is a cult aspect to all of this, that they hiding shit. I will never deny that. Ain't nobody can tell me that they not, because I done been through it. And I know what I was facing, and I know what happened to me, and a lot of other people too. However, a lot of this other stuff that we dealing with.
For the host, y'all may want to have another mod up. I'm about to drop. I got to teach class in a second, but I'm about to drop. Appreciate the build. Another mod.
Okay, I appreciate it, bro.
So all right, y'all. Peace.
I appreciate that, but y'all need to throw a lot of this shit in the trash, man. I mean, I'm gonna be honest with you.
Excuse me for a second. Hey, excuse me for a second, y'all. I'm gonna run around the corner. I'm coming right back. I hope it don't shut off, okay?
All right, go ahead. I'll stay on until you get back, because I gotta get off too in a little bit. I'll stay on a little while until you get back.
Thank you, man. Appreciate you. Hey, guys, I'll be right back,
Now,
y'all.
with the difference up with the CPN, Yusuf, I know you said you had one, but I heard, not that I need one because I don't need one, but people be asking me about it. I try try not to, because I keep hearing conflicting stuff about it. So, yeah.
Let me tell you this. I'll just tell you this. It is a gray area that you operate in because you got to give notice of what you were doing. When I opened up my bank account, I told my banker that I had a CPA, and he said, that's a good thing. My CPA also told me it was a good thing too. He told me, the person who opened up my bank account, he said, it's a good thing that you have this. So there wasn't any fraud or anything conducted with it. But I'll say this, a CPM, they weren't using that term before. They started using that term, I'll say around 2005, 2004, 2006, somewhere off in there. That's when I started hearing the term. But it's much older than that. It goes all the way back to the early 90s. What I learned about it is in a book called The Paper Trip. And it's sold by a company called Eden Press. You can still pick it up today. And what they used to do back in the day, and it's what they're doing today still, is that you would incorporate your name. Like your name is John Henry Doe. You get a company, John Henry Doe Incorporated, and get an EIN number for that name. And then you take that EIN number and then you take it and start applying for personal credit with it. And so, because the credit bureaus, their computers work off of an algorithm. There's no person doing that. And what it does is when a new number is entered, well, I'm going to give you the whole thing I did. We would go and incorporate our name, get an EIN number or a tax identification number. The next thing I did is I went to a place called Mailbox, etc., and opened up a PO box because it gave me a like a suite number back then. Then I would go into the to the DMV and say I lost my driver's license, and then I would put that address of that suite number on there, and I would also ask for a different driver's license number. Okay, after I got all that done, I would go to anywhere. Back then I went to a Zales and apply for credit. And applying for credit, I know I'm going to get denied because there is nothing in the credit bureaus for that number. But this is what they call try merging the account. That's what they mean. I apply for credit, and then once I apply for credit, what the computer does is it searches the database and it tries to match a name with an address. That's why you got to make sure you use an address that has never been used before. Never been used before in life. All right. That's what they go off of, because a lot of people have the same name, but do they have the same name and the same address? The credit bureaus don't have access to the government databases to confirm a social security number because they're not governmental entities. They are private data mining companies, family-owned businesses. They don't have any right to anything. Okay. So once you get that, you do that. And then what I did was next, I got me an Equifax account. I went through a little bit to get that. And then once I got everything in place, I got a prepaid or a secured credit card for $500. I watched this guy on YouTube. He gave me the game. And so I figured out the algorithm. The algorithm to credit cards is this. You can start with just a $500 secured credit card. If you just pay your bills and buy groceries with it, and every time you use it, pay it off within 3 days after you use it. Do that for 6 months straight. At the end of 6 months, they're going to give you your money back. Immediately ask for an increase in the credit line. Ask for a $1,500 increase in credit line. Now it's $2,000. You're going to keep doing the same thing. You're going to buy groceries and pay your utility bills with this credit card. Because you got to pay your groceries and utility bills anyway. All right. Might as well use the credit card, because the credit card is better because you're going to get points. You're going to get all kind of benefits. You don't never use a debit card. Throw a debit card away. A debit card is the worst shit in the world to be using, to just contract any kind of business with. Use a credit card for that. It's a pass through. Okay. So then after another 6 months, I asked for another increase. I asked for a $5,000 increase on my credit line. At the end of 2 years, by this time, you're going to start getting credit offers. Okay. If you're going to apply for credit, apply for 3 different credit cards at the same time. Do not use Chase though, because Chase is very a stickler for this kind of thing, because you're going to have 3 inquiries. You want them inquiries to hit the credit bureau at the same time, so the other companies don't pick them up. So you're going to apply for 3. You're going to get approved for all 3. All right. Once you get your credit, what they are monitoring is your credit utilization, which is 33% of your credit score. And of course, you don't want to miss any payments. As soon as you get the credit card, you're going to connect your bank account to your credit card. You're going to turn on automatic payments. That takes care of 30. You don't, and you want to do minimum payments, that's fine. The point is you don't want to miss any payments. But what you want to do, because you're establishing credit, is to pay it off in the first 3 days. Every time I use that credit card, I pay it off completely in 3 days. And that's why it's good to use $500 so you don't get in trouble charging more on the card because you got a $5,000 limit and you think you got $5,000 worth of free money. You don't have $5,000. And plus you got to keep it under 10% debt to income ratio anyway. And I'm even going to say this. 10% ain't good enough because that's going to make your credit score fall. You should get you a MyFICO account and get you a MyFICO account. That's one of the best things. I use that to this day. MyFICO to monitor my credit. Excellent tool to monitor your credit with. I also have an Equifax account that I do it with as well. And then after you do all of that, now I'm going to start applying for business credit. All right. Once I get my DUNS number, you're going to get that for free. I'm going to have to personally guarantee a couple of things in the beginning because I'm trying to get 5 trade lines. All right. Once I get those 5 trade lines on my business credit, then that's when I'm off to the races. And you get your first business credit card, you're off to the races after that. And then once you start getting your business credit cards, you stop using your personal credit cards. Stop using them for anything. You might want to use a little one every now and then to keep them alive. To keep them open. But you don't do that. You do everything on your business credit cards after that. And now you're in the game.
Yusuf, is there a way that I can personally inbox you or some way I can get in touch with you in regards to questions and on this path that I'm trying to take? Because I know, I may need some questions.
I'll tell you what, if anybody want to email me, here my email is hfrngmg@gmail.com. hfrngmg@gmail.com. You do that, and I'm trying to tell you, it's like look for, the whole game. It's no conspiracy theory or mystery to this. Everything I'm telling you is what all the wealthy people do. They all do the same thing. They all work toward taking everything out of their name and putting it into some business structure, trust, or something like that. That is the game, to not have any income. As I said, watch the video from Lindsay Williams on Secrets of the Elite on YouTube and let him tell you. He's going to explain the same thing. He said the object of the game is not to own anything and not to have any income.
So HFM?
HF as in Frank.
Okay.
R as in Ron, N as in Nancy, G as in God, M as in man.
Wait a minute. You're going too fast. You know your email. I don't know it.
H as in house.
Okay.
Yusuf. H as, okay. Yeah, I'll put it in
that'll work. That way it's already in there because I'm trying to write it and I'm.
All right, there it is. I just put it in the chat right there.
All right.
You can email me right there. But the object of the game, man, is this private ordering, and it is to. Your object of the game is to be an investor eventually, obviously, but not to have anything in your name. You don't want anything in your name. The public punishes you for that. You've been taught to put everything in your name. There's a book called The Rockefeller Files by Gary Allen. It's called The Rockefeller Files. Read that because it's talking about how the Rockefellers set up their stuff. And listen what he tell you in there. It's called Rockefeller. You can Google it right now. Put in RockefellerFiles.pdf. The Rockefeller File. It's by Rockefeller Files. The Rockefeller Files. All
right, gentlemen. I appreciate y'all, man. I appreciate you, fam. I appreciate your knowledge and everything, man. I'm gonna go ahead and let somebody else get up in the panel. I just wanted to say, man, I appreciate you too, big bro.
You're welcome. I'm going to leave y'all with this. It's public and private, and they don't mix. Don't let these people, when people come in here and they start talking about statutes, codes, rules, and regulations, they beginners. That's what we all start with. Studying the statutes, the codes. As a private, when you private, you're not into that. You study private ordering. Private ordering. That is what you're supposed to be doing. You're supposed to be arranging your affairs to shift liability from yourself onto some sort of other entity. The public only deals with artificial persons. Go create you one that you control so you can interface with the system. You're not supposed to be interfacing with the system, and stay out of the goddamn courts. You need to learn the law of attraction so you'll stop attracting adverse situations into your life that cause you to go into court.
I know that's right.
Anyway, I'm out, man. Hope that helps. I know that probably
Much love.
satisfies some of the shit y'all want, but hey, that's what I got for you. Y'all take it easy. I gotta go.
Much love. Much love. Appreciate that.
Peace.
Peace on to you.
Yeah. Damn, that was a lot, bro. Yeah, finally. You guys learned something. Man, tell you straightforward. Keep your things private, man.